Thank you all for joining us this afternoon. We're going to go through a presentation here that'll cover a number of stewardship topics. We'll talk about easement monitoring, we'll talk a little bit about enforcement, and then also easement administration actions, which are NRCS's authority to grant post-closing modifications. So we'll start with just a quick reference here to the places in our NRCS's policy where you can find information about monitoring, enforcement, and easement administration actions. So as we go through the slides, you'll see there's probably a lot of text on the screens. We're not going to cover every single piece of it, but hopefully it'll serve as a reference for you if you want to kind of go back after this presentation or find out more information about the topic. So we'll just start with just a quick overview of some monitoring, right? From NRCS's perspective, in general, we do monitoring for a number of reasons. First, we want to make sure the integrity of the easement is maintained, right? That it's meeting the goals and objectives of the program itself, of NRCS's FRPP and ALE programs, but also your entity goals are also being met. So kind of a combination of those two things. We identify any necessary actions during that time. And then to me, one of the most important parts of this is maintaining relationship with our landowners. So again, the note here is that our most successful easements, both I find on the US held easement side of our programs and the entity held programs, are where we have an active and engaged relationship between all the parties, landowner, easement holders, and the government. So we have within NRCS2 kind of we have kind of a major division between what we call our stewardship lands, and those are the easements that are held by the United States, where we are listed as the grantee on the easement deed, and then our non-stewardship easements, which are those easements you folks hold, or other eligible entities of government. The US is generally not a grantee on these deeds, but we have a third-party right of enforcement. So that's the kind of large division between our easement programs. So just a quick list of, on the screen you're seeing a listing of what our stewardship lands would include. Our current programs, right, would be our wetland reserve easement program and our emergency watershed protection floodplain easements, our healthy forest reserve program and our other stewardship lands. And then we have some of our programs that are no longer funded or have been rolled into other programs, like the prior wetland reserve program that has become part of the ACEP wetland reserve easement program now. On our non-stewardship lands, the primary program there would be our ACEP-ALE, right, Agricultural Conservation Easement Program, agricultural land easements, and the predecessor programs for those, which would have been the Farm and Ranch Land Protection Program and the Grassland Reserve Program. So those are our kind of larger non-stewardship land programs. So just kind of a quick overview here of kind of monitoring enforcement responsibilities and what's expected during monitoring for these programs. So in our non-stewardship lands, eligible entity is responsible primarily for monitoring those properties and providing a monitoring report, which also looks at the annual ownership verification. So if an entity has entered into an agreement with NRCS through the acquisition of one of the easements under these programs, you are responsible for conducting annual monitoring to ensure compliance with the terms and conditions. And that is spelled out generally in your program agreement and within the easement deed. And the specific monitoring requirements are set forth in the agreement, again, and in the terms of the easement deed. So the minimum requirements are that monitoring is conducted annually and that monitoring report is submitted to NRCS annually. When NRCS receives those annual monitoring reports, they're reviewed each fiscal year and then entered into our easement business tool. That's where we keep the records of the lifespan of our easements, included monitoring. And we use that information both for kind of our own compliance, but we're also mandated to actually report to Congress each year on our easement monitoring activity. So we upload those into our business tools, and as you can imagine, with over 20,000 easements, just uploading the documents themselves is a considerable workload. We also use those tools to monitor, to keep records of non-compliance or action items that are needed to follow up with the entity. So annual monitoring can be conducted through review of the most recent easement imagery, right? So usually that includes some kind of remote sensing using aerial imagery. That we do that on our own US held easements as well. We also conduct imagery reviews to look for kind of major changes on the easement. So I think this is one of the big takeaways that I would like folks to remember, is that you as the eligible entity have the primary responsibility for enforcement of the easement, and if the program required it, the ALE plan, that remains a responsibility of the entity. NRCS will clearly support you in your enforcement activities, and we do that quite often, but you are kind of primarily responsible for that enforcement activity. One place where the USDA and NRCS is responsible is our highly erodible land and wetland compliance provisions, where the agency is primarily responsible for that work. And so if NRCS were to determine that an agricultural producer is out of compliance with the highly erodible land provisions, NRCS would notify you as the entity holder of that determination after the landowner has exhausted all of their appeal and waiver rights that are afforded to them. So there's a process for that, and that is when we would notify you of those of NRCS's determination of non-compliance and what kind of work or mitigation would be needed for the landowner to bring themselves back into compliance. But I think, again, the takeaway here is NRCS is responsible for that, for those requirements. So if in our other kind of NRCS USDA activities, we somehow become aware of some type of violation on the easement, then what is supposed to happen there is NRCS will provide you information about the suspected or potential violation, so that you can investigate whatever the circumstances are, and then report back to NRCS about the findings and resolution. Again, due to the nature, NRCS is not, because we're not the primary holder, will not be doing the violation enforcement, and that would be up to you as the eligible entity to go through your standard process of notifying the landowner or violator if it's a third party, and then work through the standard procedures for correcting the violation in accordance with the terms and conditions of the easement deed. The place where NRCS would get involved here, and thus far I've not seen this exercised because we have great relationships with our partners, is where where the eligible entity could, if they failed in taking an enforcement action, that is where NRCS might exercise its right of enforcement. Again, hopefully this remains as rare as it has been. So a couple kind of small variations here that I want to make you aware of. So the existing grassland reserve program easements that were held by eligible entities, we call those our non-stewardship GRPs. In those specific easements, NRCS completes on-site monitoring 1 in 5 years. So 1 in 5 years, NRCS should coordinate with you as the entity to go onto those easements and conduct the on-site monitoring. And then the other 4 years, we would rely on your entity monitoring to provide us monitoring reports. For all of our non-stewardship easements, which would be our ACEP-ALEs and our non-stewardship FRPP easements, you as the eligible entity are always responsible for that monitoring. There is a small historical period between 2006 and 2008 where we have what are called our stewardship FRPPs, where those easements, NRCS was also listed as a grantee on the easement deed, and we take a similar monitoring approach to the non-stewardship GRPs, where 1 in every 5 years, NRCS will also conduct monitoring along with you as the primary holder to do that on-site monitoring. And a note here we have is that NRCS may accompany you as the eligible entity at your request to conduct monitoring on all of our ACEP-ALE and FRPP easements. And that would be completely at request, and our folks are generally happy to do that, but it is not a requirement. So the secondary topic we're going to talk about today are our easement administration actions. The policy for that can be found in our manual in 440-528 subpart R. That's the manual that guides how NRCS evaluates an easement administration action. And generally, the definition are these are changes post-closing to our easements. So anything that would affect the easement rights or deed language or scrivener's errors, anything that can change something related to an easement right would be considered an easement administration action. They come in 4 main forms. Easement subordination, so that allows some kind of right to be made superior to the easement without changing the easement boundary. And generally, those would be things like rights of way to allow like a power line or pipeline to affect the easement, or maybe a road widening. So the easement stays in place, but the easement rights are subordinated to that interest to provide the public right of way or publicly beneficial right of way. A modification, which modifications kind of come in 2 flavors. So they can either adjust the boundaries of the easement to resolve some kind of issue, or maybe to adjust the terms of the easement, and that would be considered an easement modification. An easement exchange would be where we actually kind of cut out a piece of the easement and replace it somewhere else, so not adjacent to the original easement. So that would be an easement exchange. And then easement termination, which would be releasing all of the rights held by the United States in the easement. And I'll just add a quick note that thus far we have not actually terminated an easement. So the other note here on the slide is that NRCS is never required to subordinate, modify, exchange, or terminate any of its rights or interest in an easement. These administration actions are completely discretionary and voluntary and are not subject to appeal rights. So NRCS's decision to either allow or deny an easement administration action is not subject to appeal. So a little bit about process and procedure and requirements. So we are required to review them under our ACEP regulations and policies and NEPA, and even the easements that were prior to the agricultural easement program's kind of existence are now considered ACEP for the purposes of the easement administration action process. That was due to specific language in the Farm Bill, which actually made kind of management enforcement and easement administration actions subject to the ACEP regulations. Obviously, from our perspective, avoidance is always our preferred alternative. There needs to be a really good reason why whatever it is can't avoid the easement, and why it would be a good idea to kind of release or subordinate the rights that we've spent public and donor and fundraising money on. And we've also said that that place is that important that we need to protect it. So again, avoidance always is our first kind of line of defense. Now, when we can't avoid, right, then the next kind of way to approach this would be minimization of the impacts to the easement area, and also compensation for those impacts. And compensation there generally means enrollment of replacement acres. We don't mean monetary compensation. So other kind of policy requirements are that generally, unless we meet very specific exceptions, no more than 10% of the original easement area can be affected by an easement modification, exchange, or termination. And then for subordinations, it's limited to less than 2% of the original easement area. And so subordinations should have a very, very limited impact to the easement. So, you know, we have a pretty, we've been doing easement administration actions now since the 2014 Farm Bill, and we have a pretty set process and procedures for how we kind of go through the review, looking first at whether the activity could be avoided, and then kind of how we review the proposed mitigation to help us understand the project. A note here, though, is that easement administration actions should generally come from something that was not anticipated when the easement was closed. So, such as like a new highway or bridge construction, something that was not in the planning stage when we enrolled the easement. NRCS by policy should actually not be enrolling easements that are designed to stop or delay development projects. We don't want to get into that conflict. And so if an easement is enrolled, easement should not be enrolled for the purposes of stopping an infrastructure project. So who can ask for an easement administration action? They can be requested by almost anyone. The landowner themselves could request one. You as the easement holder could request a change, or a third party, an unaffiliated third party, such as a utility or a state or local government could request a change to the easement. And in a few very limited circumstances, NRCS has even been the requester of the easement administration action to resolve specific situations. One note is that the landowner and you as the easement holder must agree to the easement administration action before NRCS will consider approving. And we don't actually have authority to approve it without your and the landowner's agreement. We've always had this policy since the beginning of the easement administration action policy, but it was actually put into the regulation in the 2018 Farm Bill to cement that as a requirement, even though we've always had it. So the other kind of important notes is whoever is the requester of that change or easement administration action is responsible to provide all of the documentation needed for NRCS to evaluate the situation and for the costs. And so that may include things like use PAP or yellow book level appraisals and appraisal reviews, surveys, the NEPA work itself, any kind of documentation or studies, cultural resource assessments, anything that is needed by NRCS to review the request and that we would like to see is the responsibility of the requesting party. And that is also in the statute, which mandates that NRCS cannot expend funds on reviewing these activities. We can spend staff time, but not funds on creating the background documents to evaluate. So, other important pieces here, you guys know this more than us, NRCS does not provide tax advice. And so an easement administration action or a post-closing modification could have detrimental effects on someone's tax benefits that they have have received as a result of enrolling their property into a conservation easement. And so NRCS has a requirement that the landowner and even you guys as the entity should work with the landowner to ensure they consult a tax attorney or other qualified professional to understand the risks of approving or requesting a post-closing modification. This is an important and near and dear point to my heart, is that we don't use easement administration actions to address easement violations. So, for example, let's say your easement deed included a riparian protection clause, and so the landowner was prevented from farming in the riparian section of the farm, and there was a deed term describing that. And let's say they went in there and farmed it purposefully or accidentally. We won't change the description of the riparian area to address that violation. That violation would need to be addressed through restoration and mitigation to resolve it. The deed cannot be amended to kind of get the person out of a violation, even if it was accidental. And so this is another important one, right? NRCS is the sole entity on behalf of the United States to alter our own interests in the easement deed. And so a note here is that when we do go for a post-closing modification or easement administration action, we may be looking at this from different perspectives. You, as the entity, and your landowner may be looking at it to resolve kind of a very specific situation on the ground, whereas we have a specific set of regulations and policies that kind of color our view of how we might approach these situations, looking at it from a national perspective and against the greater easement community, and then also workload and costs and all the other things that might affect our decision. And so just realize as you request one of these or analyze one of these that, sometimes there may be differences in our approaches. What is important to note, though, is if you are going to kind of analyze or recommend an easement administration action, that you should really know that you're going to follow your own policies and procedures for reviewing that to ensure you're being fair and equitable to all of your landowners, and that you're following a specific process to analyze it. And NRCS does need to see kind of your decision and rationale in supporting whatever that request might be. So I'm not going to dig into each of these in any depth, but this would be the requirements for NRCS and our policy for reviewing a subordination. The piece I will note here is in number 2 and 3 would be for a subordination right. We're talking generally a right of way for a public infrastructure project. The project would need to be in the public interest generally, and should further the practical administration and management of the easement area or program, and it should increase the conservation functions and values or have a limited negative effect on the conservation functions and values. So that's going to be one of the big drivers of our decision whether to authorize a subordination of not is how can we limit those negative effects on the conservation functions and values. One way to do that is to ensure no net loss of easement acres. So in some cases, for an example, a overhead power line may have very little effect on a grazing operation because cows can continue to graze under there, and it may have almost no effect on the property and the functions for which that easement was enrolled. But let's say we were in a grassland easement that was designed to help less a prairie chicken. That same subordination may not be authorized because overhead power lines create perches for raptors, and so that may be a really bad idea in that ecosystem. And perhaps that might be a really good reason for the power line to avoid us, or perhaps look at a different way. Perhaps they can bury the power line in that easement to avoid those impacts. So modifications and exchanges generally have the same requirements as each other. And here you'll see, importantly, in number 4, they shouldn't have a reasonable alternative that will avoid impacting the easement area. And then if it can't avoid it entirely, then we need to minimize it. So again, our goal is to avoid impacts to our easements, and where unavoidable for environmental reasons, or maybe there's geology that wouldn't allow it to avoid the easement, or some other really good reason it can't avoid, then we would want to mitigate. One thing to note here is when we are looking at avoidability of a change to an easement, the cost to the requester of avoiding the easement is not something that NRCS looks at. That is not what we were instructed by Congress to look at. So, for example, if that power line needs to run an extra 10 miles to avoid us, that's not something we're going to look at. So just looking through a few more of the requirements of modifications and exchanges, you'll see in number 6 that the result must be equal or greater conservation functions and values to the United States, and that is where we use NEPA to address and to understand the impacts to the easement. And then in number 7, result in equal or greater economic value to the United States. And usually that's going to require a before and after appraisal and appraisal review to understand the economic effects to the easement. The other one I'll point out there is number 8. No matter kind of what the NEPA and the economic evaluations say, our baseline is always no net loss of acres in the program. So at minimum, a 1-to-1 land swap is or enrollment of land is always going to be required for a modification or exchange. So termination, again, we haven't seen a termination request that has been approved here. It's probably hopefully going to continue to be a rare request, but you'll see in number 5 that generally even terminations can only affect 10% or less of the original easement area, except under specific circumstances, which are further described in our policies. And those further circumstances are pretty high bar to meet. And so one of the reasons I think we haven't seen a termination. The other are, right, most people don't want to see the easement be terminated. You need the landowner or the entity, and us as the government, the termination would have to be in our interest to do so. The other thing I'll point out is before NRCS can make a decision on a termination action, we actually have to notify the House and Senate Ag committees about that termination. So they've also kind of indicated through that requirement that they are also concerned that we don't terminate easements. So let's talk a little bit about going through the process of requesting or reviewing an easement administration action. And obviously, what I'm going through here is from NRCS's perspective, the things that we would be looking at. So requests for easement administration actions first go to the state conservationist who has responsibility for that easement. So they're going to want to see that concurrence from you and the landowners, that you both concur with the project, and they're going to want to see from you as the eligible entity that you've gone through a process to review the request and kind of how you made your decision. They're going to go through and ensure that all those thresholds that we kind of listed out here in the policy have been met. They're going to look at the NEPA, and they're going to look at the valuation to ensure those are all met as well. For our ACEP-ALE and FRPP easements, we also are required to review any request to affect farmland under the Farmland Protection Policy Act. One way we do that is using the land evaluation and site assessment score, the LESA score, to compare or rate any impacts we have that might convert farmland. So even though we have specific policies under NRCS for evaluating these kind of requests, we're also still bound by other federal laws that would guide the agency's activities, such as NEPA and the Farmland Protection Policy Act. For our wetland easements, we're also guided by some executive orders that are designed to avoid impacts to wetlands. So, as we move through, the state conservationist then has to determine that the requested easement administration action is appropriate based on the things they've reviewed. If they have reviewed those documents and find it not appropriate, the state conservationist can notify a project proponent that the request is denied and that no appeal rights are available. So the state conservationist there has the right to deny a request at any stage. If they determine the action is appropriate, then their request, along with supporting documentation, is submitted to our national headquarters, where my team would be part of the review of that in order to assist our easement program division director in making a final decision. So the state conservationist then recommends review and approval of the project to the EPD director, who then assigns it to generally my team and other subject matter experts within the easement program division for review. So I'll just a quick note on that procedurally. You know, the longest part of these projects is generally during the review process between gathering documentation, understanding the scale of the project. We looked recently at some record keeping about kind of the length of time for the national headquarters section of the review. On an average, these take about 45 days for headquarters approval or denial of the project. I'll say the vast majority, by far the vast majority of requests that make it to headquarters are approved because they've gone through the state level review to make all those underlying findings. But every now and then we do still find one that needs some additional information or additional mitigation. And then with that additional assistance from the easement program division, we're able to kind of bolster the mitigation or documentation in order to get to an approval. Under the easement administration action rubric, we also have the ability to do kind of title corrections and legal adjustments. And so these things we kind of categorize as minor legal corrections. So they're going to be things like maybe a survey error at the time of enrollment or Scrivener's errors. And so those can be completed through a much more streamlined process than the other easement administration action procedures. Usually these aren't going to require a full force NEPA evaluation or appraisals, and these are done much more quickly and with far less documentation. So we do have that built into our policies to kind of have a streamlined process to accomplish those things. The other kind of things that fit under this section of our policy are building envelope changes, right? So let's say you have a building envelope described in the easement and no one's built in it yet, and the landowner requests a change to that building envelope, the location of it within the farm. That could be reviewed and approved under our legal adjustments authority. And so in that case, it is again a more streamlined approval process. There will be more so than a typographical or Scrivener's error. We'll probably need to do some NEPA work, a more limited NEPA work, to ensure the effects of where the building envelope was originally to kind of the proposed change area are similar or will have less impact than the original site. But for the most part, that's a pretty quick and easy process. We've also used that same authority to approve changes of legal access to properties, right? So all NRCS easements require us to have legal access, and sometimes that needs to be changed. So we change it through that process. And we've also used that authority to approve temporary work areas for things like road, like a state road authority. So they may need a staging area for their trucks during an interstate expansion project. And so we can give kind of almost like a permit using this authority for, it's not actually a permit, but similar to a permit for them to allow the trucks to use a portion of the easement and then restore it after the work is done. And, you know, we ensure things like they're responsible for any environmental impacts they may have. Let's say the truck spilled fuel on the temporary work area, that they would be responsible to clean it up. And so this legal adjustment section allows us to make a lot of small legal changes or non-permanent changes to easements. And so one thing to note here is for all of the major easement administration action types, subordination, modification, exchange, termination, we have checklists for those. But for the most part, for things like Scrivener's errors, NRCS does not have a checklist because they're kind of done on a case-by-case basis. We do have a checklist available for changes in building envelopes and for legal access. So those are available through your local NRCS office as well. Those are not policy documents, but just helpful guidance for us to ensure everything is meets our policies as we review those types of requests.